Hello viewers, this is Dr. Kashinath Neharkar and I welcome you in my YouTube channel at lecture series on property laws. Friends, in this lecture we are going to discuss the principle relating to transfer of property in favor of unborn person under section 13 of the Transfer of Property Act 1882. Friends, before that, please subscribe this channel and press bell icon. So let me start with today's topic. Friends, we have discussed what is the concept of transfer of property, and it is the transaction between living person to transfer their properties. So it is the voluntary transaction between parties by which they want to transfer the property. So both parties that must be existent at the time of transfer of property. This is very important, essential for valid transfer of property. So the transfer of property is nothing but the transaction between living person. So living person means both persons must be living at the time of transaction of property. Therefore the property cannot be transferred to unborn person because it is not the living person at the date of transfer, because that person is not the person who is in existent at the time of transfer. While discussing the essentials for valid transfer under section 5, we have discussed all this. Please refer that lecture on my YouTube channel by which you can understand. See, therefore section 5 of the act does not allow the transfer of property between living person and the person who is not yet in existence. Therefore this property cannot be transferred to unborn person. This is the reason why. Therefore, but the property can be transferred for the benefit of unborn person. The property can be transferred for the benefit of that person who is not in it in existence. So section 13 can be the exception, or section 13 is evolved in such a manner by which it shall indirectly satisfy what the essential conditions for valid transfer. So let me see who is unborn person. See, under Hindu law or there under certain laws, even the person who is in womb of mother is considered as a competent transferee. There are many provisions you can see, but here we must see who is unborn person. And according to section 13, the unborn person means the person who is not in existence even in the womb of mother. So whether the property can be transferred to the person who is not yet in womb of mother, the answer is yes, but it shall be transferred only as per the process or the provision that is provided by section 13 of that act. Let me see how that property can be transferred to that person. But before that, let me go through what the language of section 13, though we are not going to discuss that definition in detail. We are going to discuss what the essential or what is the process through which the property can be transferred. But before that, we must see what is the language. See, the transfer for the benefit of unborn person, whereon a transfer of property and interest therein is created for the benefit of person not in existent at the date of transfer, subject to prior interest created by same transfer. The interest created for the benefit of such person shall not take effect unless it extend to whole of remaining interest of transferor in the property. This is the process, this is the mechanism which is evolved by section 13 for the transfer of property for the benefit of unborn person. Let me see the illustration also. See, a transfers property of which he is owner to B in trust for A and his intended wife successively for their lives, and after the death of survivor, for the eldest son of intended marriage for the life, and after his death for his second son, the interest so created for the benefit of eldest son does not take effect, because it does not extend to whole of his remaining interest in the property. So illustration provides that, see, property can be transferred to unborn person, but by creating prior life interest in favor of person who is living at the date of transfer, and ultimate beneficiary should get property ultimately. So this is what the illustration that is provided. So let me see what is the process, or what are the essentials by which the property can be transferred for the benefit of unborn person. See, this is the process. In pictorial form you can see how the property can be transferred to unborn person. Let me firstly see the essentials. See, the first essential of section 13 is no direct transfer. So it means a property cannot be transferred to unborn person directly, because section 5 of the act does not allows the transaction between living person and the person who is not in existence at the date of transfer. Therefore property cannot be transferred directly to unborn person. This is the rule. See, because it does not fulfill the valid conditions of transfer of property under section 5. Then second thing is that, for if the transferor wants to transfer the property for the benefit of unborn person, he has to follow what the mechanism that is provided by section 13, or that mechanism is a creation of prior trust. This is the mechanism, this is the process. So section 13 intends to fill gap between transferor and transferee, ultimate transferee. So he will act as a mediator. So he will hold the property in a trust. So therefore section second essential is that the property can be transferred through mediator who is preceding to unborn person. See how the living condition is satisfied, we can see, we can understand through this essential. So see, therefore transferor has to create prior life interest in favor of somebody who is in existent at the time of transfer, and who will be the person who is preceding to unborn person. It means after that person, or within the lifetime of that person, the unborn person will come into existence. See, therefore the prior life interest in favor of person living at the date of transfer shall be made. Then it is duty, now it is a role of that mediator, it is a role of the person in whose favor prior life interest is created. See, you must understand what is the meaning of prior life interest. Prior life interest means it is a prior to unborn person. One thing, his interest is prior to unborn person, and secondly his interest is limited only. Life interest means he can just enjoy that property for given duration. He cannot dispose the property, because such powers are not given by transferor to him. So his interest is a limited interest, life interest, whatever the period which is given to him. So during that period he is under a certain obligation, and his obligation is he holds that property in a trust, interest for the benefit of that unborn person. It means he has to work as a carrier of that property. He must carry the property from transferor to transferee. He must take the property from transferor. Then he has to take care of that property. He can enjoy that property only, and he has to take care of that property, and he has to wait till the moment, till the date unborn person comes into existence. So till that he has to take care, and finally as soon as that person comes into existence, as soon as the ultimate beneficiary comes into existence, it is his responsibility to deliver that property. So he fills the gaps between these two persons. So such person holds property for transferor in a trust, and he delivers it to transferee when he comes into existence. So you can see how the transferor, he wants to transfer that property to ultimate beneficiary, unborn person. But see, unborn person is not in existence, so how that person can give that property to unborn person? And even such a transfer is allowed, that is not in the interest of property, because if such transfers are allowed, then the property has to wait to its owner to come in existence. So that is not in the interest of property. That property may not be useful for society, etc. There may be certain reasons why it is not in the interest of society, so that property should not be required to wait for its owner. Therefore this is necessary. So it cannot be, firstly it doesn't satisfy section 5 of that act, because he is not living person. Then if that person wants to, if this transferor wants to transfer that property for the benefit of unborn person, then he has to follow what the process that is provided by section 13. And for that purpose, transferor has to create prior life interest in a second person, who will be in middle of transferor and ultimate beneficiary. And then he has to hold that property, he has to take care of that property, and then it is responsibility to deliver that property to unborn person when that person comes into existence. So how, see, the person in whose favor prior life interest is created, he works as a bridge between transferor and transferee. So this is second essential. Then third essential is that transfer of absolute interest in favor of unborn person. Transfer of absolute interest in favor of unborn person. See, when the unborn person ultimate beneficiary comes into existence, absolute interest in that property should be absolutely transferred to an unborn person, that person who is ultimate beneficiary. At that time, no right of transferor shall remain in that property. It means that ultimate beneficiary should become ultimate absolute owner of that property. He will be entitled to dispose that property also, because when the property was in the hand of the person in whose favor prior life interest was created, then that person was holding only limited interest, and some interest were with the transferor. But once that property goes to ultimately, transferor's interest will cease from that property. So that interest shall be given to him, and the whole of remaining interest of transferor should be transferred to transferee, that is unborn person. For example, illustration, he transfers his property to X for his life, and then to eldest son of X absolutely. So the transfer which is made for the benefit of eldest son of X is valid. So this is the process through which, here A is a transferor, X is the person in whose favor the trust is created or prior life interest is created, and X eldest son is the beneficiary. So regarding that, there is case law in Girjas Datta versus Dattadin in 1924. The court decided the case relating to that, and where the court observed that the transfer of property to unborn person with a limited life interest is not valid. So friends, this is the mechanism, this is the process by which the property can be transferred for the benefit of unborn person. So the word which is used, you must remember the word which is used under section 13, and that word is property, transfer of property for the benefit of unborn person, and not transfer of property to unborn person. So friends, if you like this video, please like it, share it with your friends, and do not forget to subscribe this channel. Thank you friends.